Good morning, Your Honor.
Good morning, Mr. Bogus. I'm sorry I'm 2 minutes late.
Oh, no problem.
We've got someone in here trying to get me to sign an order stopping a sheriff's sale at 10 o'clock.
Oh, wow.
And I have before me your motion to reconsider. Are you expecting opposing counsel?
We haven't spoken about it, but I would have assumed I know he's opposed. I know he wanted the case to stay dismissed. Um, I kind of thought he would be here, but
I mean, he filed a response, so it's not.
right.
Tell you what, I'm going to give him a couple minutes.
Okay, sure.
Ms. Rouse, I trust you can show that you provided him the Zoom link.
Well, I'm gonna have to search for the name because
All right.
usually one site will send me a link, and if they don't put emails in there, what's the attorney's name? I can try to search.
Eric Scott.
Okay, let me see. Okay, there's his email. Okay, 6 days ago. This is the Aniele Castellan James.
Yes.
Yes, sir. I sent it to him.
Okay, very good. For the record, we're on DC 19-17912. And I've dialed the number for Scott and Viscuso PLLC. Mr. Scott, this is Judge Mike Lee, 95th District Court, calling you on Castellan James or Jaime, I'm not sure, versus Smith. Mr. Bogus is currently in a Zoom. He's made his appearance by Zoom on the motion to reconsider. Don't know. I mean, we've got a motion to reconsider set at 10 o'clock this morning. Waiting on you. I'm going to try your firm's main phone number and see if I can reach you. Hope to see you soon.
Would you like me to email him, Judge?
Not a bad idea.
Okay. Just send it. Okay, Judge, he just
Yes,
responded, and said, I had an issue and will be on in 5 minutes.
very good. Then we're in recess for 5 minutes.
Okay.
And I'm gonna leave the virtual bench here.
Yes, sir.
Yes, sir.
Hi.
Hello.
Hello. What hearing are you on?
I'm with Aspen Goddard.
Okay, are you for 10 or 10:30?
It's 10:30.
Okay, I'm just gonna put you in the waiting room till we're ready for you, okay?
Okay, perfect. Thank you.
You're welcome. Okay, now he's asking for the ID. Let's see. There he is.
Okay, I see Mr. Scott has joined us. Mr. Bogus, are you still there?
I'm here, Your Honor.
Very good.
Can
Welcome to
everybody hear me?
95th District Court. There you are, Mr. Scott.
I'm deeply sorry. I apologize for the delay. I'm sorry. I apologize.
Fair enough. Welcome to 95th District Court. I need to jump through some hoops. This proceeding is being conducted remotely, obviously. Nonetheless, it is conducted pursuant to the open court's provisions of the Texas Constitution. For the record, the courtroom door is open. Public, I've actually had a member of the public in here this morning seeking an emergency order. So the public is available to be in this proceeding if they were to have an interest, but beyond that, we're broadcasting this on the court's YouTube channel. Because it's being broadcast on the court's YouTube channel, I need to advise the parties and the public, if anyone happens to be watching, that reporting of this proceeding is, recording of this proceeding is expressly prohibited. Absent another order of this court allowing recording of this proceeding, and I have not issued such an order. There is one record and one record only that comes out of this proceeding, and that's the record maintained by the official court reporter of the 95th District Court, Ms. Rouse. And that said, I'm calling DC 19-17912. I'm not going to butcher the name. I invite the parties to identify themselves and who they represent, beginning with Mr. Bogus.
James Bogus, Your Honor, on behalf of the plaintiff.
And Mr. Scott.
Eric Scott on behalf of the defendants.
And again, welcome to you both. Mr. Bogus, it's your motion. I'm going to tell you before you present it, and I'll give you the opportunity to present it. I understand the argument on sufficient time for discovery. I also am not a believer that it has to wait until the end of, till 30 days before trial for a no evidence motion for summary judgment can be presented. It, by all accounts, there appears to have been a sufficient time. And honestly, I don't know how COVID kept you from getting, and here's where you're going to have to convince me. How did COVID keep you from getting affidavit evidence or declaration evidence from your client, your own client, on both the matters of negligence and damages? I'm open to hearing it, but understand you're starting with that deficit.
I understand, Your Honor. Honestly, I think in this case, it was just my experience was working against me. I've been doing this for a long time, and I wasn't, this might have been the first time I had, well, not the first time, one of the first times I've had a summary judgment filed on a car accident case. And definitely the first time summary judgment was filed before we'd done any depositions. And I'm just accustomed to depositions being taken before that summary judgment is filed. And then if we don't have enough evidence through my client's testimony, then it's granted. In this case, I just, I think I just made a mistake. I should have gotten an affidavit from my client prior to responding to the motion for summary judgment, and I didn't do that. The case is not that old. It was filed, the lawsuit was filed November 6th. The answer was filed December 16th. And then, of course, the pandemic started in March. No depositions wherever. I don't think they were even requested. And that just, frankly, that just threw me off. I'm accustomed to, we don't take our own client's deposition. I'm accustomed to my opposing counsel always wanting my client, the plaintiff's deposition. And I don't even, I would have taken their clients at some point, but really I just needed testimony from my client that gives her version of how this accident happened. And she just hasn't had an opportunity to do that. And I should have gotten an affidavit. I should have done that. And now that I'm looking at it, I should have done it. If not, well, I should have done it before we filed the response. And then I should have done it when I filed the motion to reconsider. It's just my fault. It's my error, but I don't want my client to be, to lose her opportunity to give her version of, excuse me one second, her version of how the accident happened and what her damages were because of my mistake. So I just like to ask the court for additional time to do that. Even if I think my motion was filed in July, even if first I'd ask that it be granted and then reset the hearing on the motion for summary judgment and give me some time to get the affidavit. If not that, if you want to reset this hearing, I could probably get an affidavit within the next week.
Well, that affidavit would be untimely because this effectively is a motion for new trial. That would be a supplement to a motion for new trial not filed within 30 days of the judgment. As I understand it, this accident happened when your client struck the rear of the defendant's truck, correct?
Well, that's according to the police report, yes. And I believe the contact was the front of her car with the rear of the truck. Her version, I believe, will be different from the police report, which basically says she rear-ended the truck. What I anticipate is her testimony will be she was in the next lane over and it came into her lane. I don't know for sure. And obviously, it's not evidence what I say about her version.
Okay. Mr. Scott?
Yes, sir. I think you hit the nail on the head at the beginning of this hearing, Judge. While I'm sympathetic to making a mistake, in this particular instance, there's been no demonstration by counsel why he couldn't have secured his own client's affidavit or even unsworn declaration prior to either A, the summary judgment hearing, or B, filing the motion for what is in essence a new trial. And absent that due diligence, there is no reason for this court to, in essence, reverse its own decision. The evidence is what you have before you, which is the police report, which remains unrefuted. There was no evidence in support of the cause of action or the damages. I generally don't file an MSJ this early in the case, but under these circumstances, particularly when a police report is submitted by or on behalf of the plaintiff's counsel or plaintiff, and it puts the fault on the plaintiff, I'm going to go ahead and question that without taking the time or effort to take a deposition. And that's what we've done here. And again, I think my response to the motion for new trial sets forth pretty clearly, A, we don't have newly discovered evidence. And if we did, it's not material. He doesn't satisfy the necessary pleading requirements to present that to this court. And B, if we're talking about the hearing should have been continued initially, I go back to the original response, which just failed to demonstrate any diligence in attaining the declaration, or at least explaining why the declaration could not be obtained. So,
By the way, if I'm looking over here, it's because the computer that has all the case files over to my
I do the same thing.
right. So
I
I'm not looking at you. I'm listening and looking at the. And then the same goes when Mr. Bogus was presenting it. That one of the oddities of presenting these things on Zoom. If we were in the courtroom, you could tell I was looking at the computer. I'm torn in this one respect, and the only reason I'm even considering granting the motion to reconsider is the Supreme Court told us to give every leeway on deadlines to the parties during the COVID crisis. I mean, that's the only reason I am even considering granting a motion to reconsider. But I've been on the bench for a month and a day. And I've made a commitment that I'm not going to overrule the rulings that were done by the various assigned judge. This is just a personal commitment. I'll hear anything, but I'm not undoing what Justice O'Neill and Judge Wheelis did sitting in this court until there was a presiding judge as a general rule. And I can only assume that Justice O'Neill considered all of these same arguments, except at the hearing. And as a result, I'm just not going to reconsider his order. And that's ultimately where I'm gonna fall down. So
Can I say something, Your Honor?
you may.
This could be malpractice on my part. My client, I made a mistake. I really made a mistake. And I realize it's not just, maybe I made several mistakes. My client is she's greatly prejudiced by this. There's not really any prejudice to the defendant if you grant the motion, if her version of the facts isn't any different than what's in the police report. Then the summary judgment could be granted, after she's able to give her version of how the accident happened. She just hasn't had that opportunity, and that's my fault. She's left with no case at this point.
Okay.
And I mean, I'm just being honest. It's my fault, but
You have read, Mr. Bogus, you have read my policies and procedures, haven't you?
Sure. Yes, Your Honor.
Mr. Scott,
Judge, yeah, I mean,
I've done battle with Mr. Bogus in private practice. I don't know that we've encountered each other. And I've got some policies and procedures that basically that I practiced law for 35 years. And my job as a judge is to not make your lives more difficult. And yet it's your job not to make my life more difficult. Mr. Bogus just made a plea that I hear you, but boy, that
I understand.
You just said something on the record that
Again, I'm sympathetic, but you gotta, compared to Mr. Bogus's position, mine's a little different. But with that said, there was ample opportunity to do what he needed to do when he requested basically a 30-day continuance. He didn't take advantage of that, or his office failed to do so.
That's
hear
true.
you.
And
So here's what I'm going to do. I'm going to sign the order reconsidering the motion. I'm going to reset the motion for summary judgment going to reset the motion for summary I will sign an order reconsidering the motion for summary judgment, which effectively is a new trial. I will set the motion for summary judgment for hearing on September 25. That's a Friday morning at 9 a.m. I
Understood.
don't know what the status of discovery is, but I'm not delaying it for the purpose of taking depositions, including a deposition of the defendant. I'm basically, Mr. Bogus, giving you an opportunity to get an affidavit on the facts of the case on file, and then any objections to the affidavit. Should Mr. Scott have objections to the affidavit, which I can perceive that he just might.
I'm sure I will, Judge.
I'm only guessing, but I want to hear, and I want to give it an opportunity for the parties to have a full run of that. And
if I may, Judge, just to clarify a point, if the summary judgment is denied because you find that there's a fact issue as a result of the affidavit of the plaintiff, and then I'm assuming we're going to have to reset the case and get a whole new dance card punched.
yes,
Okay. All right.
I know.
Look, if I was in Mr. Bogus's position, I would be doing the same thing.
Well, I appreciate, thank you, Your Honor. I just wanted my client to have the opportunity, and
understand this, Mr. Scott, and and Mr. Bogus understands this. I'm going to hold plaintiff to facts, not speculation as to what might have happened or whatever. I mean, if she can present testimonial evidence by way of affidavit that your client did something that doesn't meet the standard of care, I'll consider whether that's sufficient evidence. But I'm not going to, assuming you, well, I'm not going to practice law for either of you. I trust you know how, if the affidavit goes beyond facts, how to handle that.
I do.
And I kind of have a sense of how this accident happened based on what I read. If it really is something different, we'll battle it out.
Okay.
I will grant the reconsideration, which effectively is an order for new trial, but it's reset for September 25. If you're available, Mr. Scott, that day. I shouldn't have jumped to that.
I am, Judge.
All right. 25th at 9 o'clock. And the court won't consider continuing that for further discovery. I understand that.
understood. Thank you, Your Honor.
All right. Fair enough. Let me even see if I need a. I will tell you what. Mr. Scott, let me ask you, and this really is not, we can go off the record.
Okay.
I haven't even looked. Are you staff counsel or are you?
I'm private practice.
You're private practice. All right. Well, I hate to say, at least you get to bill a little bit
I was
more.
gonna say,
I know that. I know you're. Listen, been there, done that. I never liked that argument when I was in private practice either. Proposed order. I can scribble on. You know what, Mr. Bogus? I would like an order in Word. I would like your order submitted in Word right away. Send it to Ms. Rouse's email address because Ms. Alonso is not in this morning. Send it in Word because I'm going to reword some of it.
Yes, sir.
All right. Have it done this
All right.
morning, and you've got Ms.
I'll have that
Rouse's email address from her sending out the Zoom link here.
I do. Yes, sir.
All right. Very good.
James,
All right.
if the judge denies my summary judgment and we start talking settlement talks, remember this day when I'm asking you to be reasonable in your numbers.
All right.
Oh, I'll be reasonable.
Okay.
All right.
All right.
Very good. Yeah.
Thank you.
Y'all are
All right.
excused.
Thank you, Your Honor.
Thank you for being here today.
Okay. I apologize for being late again.
That is all right. I understand that this is tough. I'm holding some people up right now. And that's fine. They can, and we never know because you're sitting there in virtual desert out there. So
Sure.
all right. I don't like this. I wish we were in person, but it is what it is. So thank
Okay.
y'all.
Thank you.
Thank you, Your Honor.
All right. You gonna let them all in?
Here.
Good morning. Oh, yeah. He's been here. 1 second, counsel. Yes, he was here earlier this morning. I sent him out to get a copy of the order.
Byron, are you there? Can you tell me your last name?
You have who?
Byron?
Collin County?
Byron
Yes, what's your last name?
Goddard, Godard.
Thank you.
Okay,
No,
can you put the sheriff through
Lex,
to
what's
me?
your last name?
All right,
McCullough, MCCULLOUGH.
thank you. Counsel, I hate to do this to you all. I've got the sheriff of Collin County calling about a sheriff's sale of a large piece of commercial property. I'm going to go in recess virtually here for just a moment, and then I'll be right back with you as soon as I'm done with the sheriff.
No worries, Your Honor. As long as you're not sending the sheriff after us. We're good.
Not doing it.
Hello, Your Honor. This is Max Freeman. Thank you.
Hello, Max.
Okay, I think I missed a letter. Lexi, what? Oh, you check?
Are you talking to me?
Yeah, can you spell your last name again? I missed a letter, I think.
Yeah, it's M as in Mary, CCULLOUGH.
Thank you.
How are you, Byron?
I'm good, thank you.
And Alexis?
I'm doing well, thank you.
There you go.
Thank you all for hustling up and getting those affidavits signed last night.
You're welcome. Thankfully, I was still at work.
Oh, good. Good.
Yes.
Well, we were trying to get this wrapped up for you quickly, but I realize it probably added a little stress to everyone's life.
It's
So
okay.
I'll
No
take
worries.
blame for that.
No, that's fine.
Okay, counsel, I truly apologize. It is First Tuesday. And
No worries.
it is amazing what happens on First Tuesdays. All right, for the record, we're calling DC 18 06746 Alexis McCullough et al. Versus Texas Health Harris Methodist Hospital HEB et al. Before we proceed, this hearing is conducted pursuant to the open courts provisions of the Texas Constitution. It is available to the public absent an order otherwise. We're currently broadcasting on the court's YouTube channel. I'm willing to consider, don't know that I'm willing to consider an order closing the courthouse doors, but I am willing, if y'all believe it's appropriate, to take it off the YouTube channel.
May it please the court, this is Max Freeman.
Yes, Mr. Freeman.
What we're doing is the prove up for a confidential settlement.
Right.
The defendants and the plaintiffs both feel that the amounts should be held in confidence of the settlement for different but consistent reasons. Accordingly, as to that portion of the settlement where we're talking about amount, we would appreciate if that not be broadcast live. I believe that everyone.
That's why I asked. That's all I needed was were y'all going to ask me to take it off YouTube? And I will do that unless there's someone here saying, now that I've heard a request that it be taken off YouTube, does anyone object to that?
No, Your Honor.
All right,
No, Your
and
Honor.
I will have it taken off YouTube, but before you get, the courtroom doors are still open, so this proceeding remains open to the public if anyone walks in, just for what it's worth. I will let you know if anyone other than the court's bailiff enters the courtroom. Fair enough?
Fair enough.
Yes,
All right.
Your Honor.
Yes, Your Honor.
Ms. Rouse, please stop the YouTube broadcast.